Maisha Ishmael for the plaintiff. May I proceed?
Yes, please.
Good morning.
Good morning.
Please introduce yourself to the court, spelling your last name for the record.
My name is Sam Ziegler, Ziegler.
Tell the members of the jury about yourself.
Well, when I was younger, I always had dreams of playing professional football for the Cincinnati Bengals. But I quickly realized ESPN was as close to the Bengals I was going to get, so I ended up going to law school, getting a big boy job, and I worked at a law firm for a few years. But eventually I took a huge pay cut and I became the communications director for Mayor Heisman's campaign in 2015.
And how long were you employed by Mayor Heisman?
About a year. I came aboard in March of 2014 and I was there March of 2015.
Why do you no longer work for Mayor Heisman?
Well, my initial agreement with Mayor Heisman was that I would become her press secretary when she was reelected. However, when she was reelected, she decided to go a different route, found somebody else that was, I guess, better fit for the job. And so I've just been volunteering in the community just to stay active.
You say you were the communications director. What were your duties?
I wrote speeches for Mayor Heisman, helped out with campaign messaging, which is just advertisements for Mayor Heisman's campaign and some advertisements against her opponents.
What was it like working for the campaign?
Well, at first it didn't seem like it was going to be much of a race. I mean, Mayor Heisman was polling at about 40%, and her opponents at the time, they didn't seem like they could get past 10. But that all changed once Dr. Ginger became one of her candidates.
Who is Dr. Elizabeth Ginger?
Dr. Ginger, she was the underdog for the mayoral election of 2015. She was a candidate from District 12, which is mostly made up of low-income, low-education voters. And it seemed like that's where she was getting most of her support from. And eventually, she stood out as an opponent for Mayor Heisman.
Why was she the standout opponent?
Well, when she announced that she would be a candidate for mayor, all of Mayor Heisman's opponents that dropped out of the race at that time took all their support to Dr. Ginger. She also had a lot of people who had never shown interest in voting, that was low income, low education, that was registering to vote in large numbers, and they seemed to support her.
How do you know that?
Well, earlier this year, we had a meeting, January 10th, and that meeting not only confirmed that Dr. Ginger was rising in the polls, but it confirmed that she was rising fast. We knew that we would have had to switch up the strategy for Mayor Heisman if she was going to win the election.
I want to take a moment and talk about this meeting on January 10th. Who was present?
It was Mayor Heisman, her campaign manager, Tom Lyon. Mayor Heisman hired a polling expert by the name of Chase Michael, and myself, her communications director.
What did you discuss in that meeting?
We talked about how Mayor Heisman was losing her lead in the polls and how Dr. Ginger's advantage was the low-income, low-education voters of District 12.
And what did you decide to do?
Well, that's when Mayor Heisman handed or passed out a memo outlining the strategy she wanted us to use to the end of the election.
Permission to approach opposing counsel with proposed plaintiff's file.
Yep.
Permission to approach the witness.
Yep.
Mr. Ziegler, what did I just hand you?
This is the memo that was passed out at our meeting on January 10th of this year.
Is a fair and accurate copy of the memo you received?
It seems to be, yes.
Who gave you this memo?
Mayor Heisman.
Your Honor, at this time, the plaintiff moves to admit plaintiff's 5 into evidence.
Any objection?
Yes, Your Honor. At this time, I would object on relevance grounds. May I explain?
Please.
As you can see, I'll refer you to the first page of the case law, which opposing counsel gave you during the pre-trial.
Yep.
Now, at the very bottom, there's a case called Holdonor v. Scandoni in 2012. And I'll just read from the last 2 lines. The claims for election fraud may not be based on truthful information spread for a nefarious or even undemocratic purpose. The plaintiff must show these statements were false. Now, the witness is going to testify that Mayor Heisman used this memo to outline their election strategy, and will testify that this led to further illegal dealings, as the plaintiff is alleging that Max Heisman committed election fraud. Now, none of the statements contained within this document are illegal, simply possibly nefarious or undemocratic in the eyes of the jury. The plaintiff can't prove that these statements are illegal, and therefore they're irrelevant and inadmissible.
Response?
Yes, Your Honor. This strategy is going to outline what the Heisman campaign decided to do after knowing that Elizabeth Ginger gained a lead in the polls. Now, what's important about this strategy is it's the basis for the illegal activity that happened throughout the election of 2015. What we're going to show is how this strategy morphed into illegal activity.
Do you have, do you agree with Ms. Clumhouse? Do you agree with Ms. Clumhouse's interpretation of Scandoni?
Yes, but we're not saying that this memo, Scandoni says the spread of legal information. We're not saying that this memo spread legal information. We're saying that this memo was the basis to spread illegal information. So Scandoni is not relevant to this piece of evidence.
Your objection, your last word.
Yes, Your Honor. If opposing counsel isn't using this document and that they're intending to show further action, then this statement is still irrelevant. They've already testified to the conversation, and this memo will simply be more prejudicial than probative in the eyes of the jury.
That's a whole different objection argument. Are you abandoning your relevance argument, or are you going to 403, or are you keeping with your relevance argument?
I'll obtain my relevance argument, Your Honor.
Okay.
None of the statements contained within this document are illegal. They are irrelevant.
I think, Ms. Clumhouse, I appreciate your Scandoni argument. I think, however, that that's a pretty narrow interpretation of Scandoni, which I don't think is the case here. Ms. Scandoni says that the claim against the defendant has to be of illegal activity. That's what we have here today. There's no issue with the complaint against Ms. Heisman, correct?
No, those are the charges of the plaintiff is alleged.
Right, and as Ms. Ishmael explained, she's using this to go into further nefarious activity. So on that basis, overrule.
Mr. Ziegler, according to this memo, what was the strategy for the Heisman campaign?
Well, there was a two-pronged strategy.
What was the first prong?
The first prong was titled erosion. The purpose of that strategy was to try to erode Dr. Ginger's core vote by painting her out to be an out-of-touch elitist.
Why did you paint her to be an out-of-touch elitist?
Well, the plan was to try to make it seem like she couldn't relate to the people of District 12. We wanted to make her seem like she was an Ivy Leaguer or someone who spent most of her time with wealthy people.
You said there was a second prong. What was that?
The second prong was titled education. And the purpose of this prong was to inform District 12 residents of voting requirements, such as residency requirements or the initiative to deprive convicted felons of their right to vote. But the purpose was not to remind the ineligible voters that they couldn't vote. Instead, the purpose was to try to discourage the eligible voters from voting.
How are you going to discourage eligible voters from voting?
By making them believe that they no longer had the right to vote and take advantage of the fact that they were low-income, low-education voters.
Mr. Ziegler, how is this supposed to work?
Let's say you pled guilty to a misdemeanor 3 years ago. You get a phone call saying, if you're a felon, you can't vote. And if you try to vote, you either get fined and could possibly face prison time. After that, you're asked a question, aren't you a little unsure that whether or not your crime was a felony? And are you willing to take that risk by voting? Now, if you're someone who don't know the difference between a misdemeanor and a felony, well, now you're an eligible voter who's scared to vote.
Were these the only two strategies employed by the Heisman campaign?
These were the only two strategies they discussed in front of me. I decided that I would work on the first strategy, erosion, because the second one, education, it seemed to me a lot like voter intimidation, and I didn't want no parts of it.
Your Honor, this is speculation and improper opinion.
Which one?
The witness just testified that
No,
in
which
his eyes,
is it speculation or improper opinion? Which objection are you making?
improper opinion.
Okay, how so?
The witness just testified that in his eyes, the statements that contained in this memo were voter intimidation. Now, this is a conclusion for the jury to render and not the witness.
How does that make it an improper opinion?
Your Honor,
Yep, feel free.
According to the rules of evidence, this is an improper opinion. The witness cannot testify that these statements were voter intimidation. Is this a conclusion for the jury to render? This statement is prejudicial and is intending to bias the jury and is therefore inadmissible.
That's a whole nother objection. Stick with just one. So we'll go with improper opinion, right?
Yes.
Okay. What's your response to improper opinion?
This witness is qualified to make this assessment. He's testified that he was a part of the Heisman campaign and controlled the messaging for the Heisman campaign. Now, if voters were supposed to be called, that falls within the realm of this witness's scope of employment at the Heisman campaign, and he is able to make that conclusion for the jury.
Response?
Your Honor, this is an improper opinion that the witness should not be permitted to make, and therefore it is inadmissible, whether or not these statements were in fact voter intimidation.
May I be heard on those grounds, Your Honor?
Sure.
The witness did not state that these were voter intimidation statements. He said, it seemed like to me they were voter intimidation statements. Therefore, that's why he did not work on that strategy.
How does that make it not an improper opinion?
Well, we've already laid the foundation that he's qualified to make that assessment, but he also isn't making an opinion saying that it was voter intimidation, but why he decided not to work on that part of the strategy.
Based on the arguments, I'm going to sustain the objection.
Your Honor, I request that portion of the witness's answer specifically regarding voter intimidation be stricken from the record.
To the extent that testimony came out, yes, it's stricken.
You were talking about the education portion of the strategy. Did you work on that strategy?
Oh no, that part of the strategy made me extremely uncomfortable. I don't know who Mayor Heisman got to work on that part of the strategy, but after our January 10th meeting, Mayor Heisman and her campaign manager, Tom Lyon, they met with a guy named Casey.
When did they have this meeting with the guy named Casey?
It was a few weeks later in February 28th to be exact.
Who was present during this meeting?
It was Mayor Heisman, her campaign manager, Tom Lyon, and the guy Casey.
And what do you know about this meeting?
It was held at the campaign headquarters, Mayor Heisman's. It was after hours, about 11:30, 12 o'clock. The guy Casey showed up to the building. Tom Lyon rushed him into a conference room.
Your Honor, permission to approach and retrieve previously admitted evidence and give it to the witness.
Sure.
Thank you.
Mr. Ziegler, is this the man you saw at the campaign headquarters?
Yes, this is the guy that met with Mayor Heisman and her campaign manager.
Were you there when they left?
I was there still. I was working on a pretty big project for the campaign. They left around 3 a.m. that morning. Mayor Heisman, Tom Lyon, walked this guy outside the campaign office. He had a huge envelope in his hand that he didn't enter the building with.
Your Honor, at this time, I have no further questions. Permission to approach and retrieve evidence.
Okay.
Permission to publish to the jury.
Yep. Cross-examination.